Okay, welcome to Patent Law, week 4, lecture 4. So this is our 4th lecture for the week. I think this will be the only week where we have 4 lectures. Usually it will be 3. We're going to talk now about the definiteness requirement. So specification has to conclude with one or more claims. We've talked about claims and how to draft them, particularly pointing out and distinctly claiming the subject matter which the inventor or joint inventor regards as the invention. This is currently found in subsection B of the same section 112 that we've been looking at for written description, enablement, and best mode. And so it's right there in the statute. Statutory language is particularly point out, distinctly claim, but the courts have not really used that statutory phrasing as the test here. Instead, they focus on a standard they call definiteness. And so the patent claims must be sufficiently definite. They cannot be too indefinite. If the patent claims are indefinite, then they are going to be invalid. Again, each claim is going to stand or fall on its own. Each claim is its own invention. That claim is used to determine both validity and infringement. So they can't be too indefinite or vague. They must be definite. So this is the basic rule we're working with here, but we do it again on a claim by claim basis. Some claims could be indefinite, other claims could be definite, and they will stand or fall on their own. So how definite is definite? What is definiteness required? So we're going to talk more about that in just a minute, but there are a couple of things everyone agrees on. So it's judged by a person having ordinary skill in the art, or a person of ordinary skill in the art, either way there, FOSITA, POSA, whatever you want to refer to. And so when we ask whether the terms is sort of readily understood and makes sense and only refers to one thing, we look at someone who's working in that art. We're not asking the person on the street, hey, what does this mean? Because they may not be familiar with the art at all, and they'd be like, I have no idea. So we're judging it. Does this term make sense to a person of ordinary skill in the art? And then also, it's judged at the time the application was filed. And with any other claim language, we can look to the language of the specification, the longhand description of the invention, how it's work, how it's an improvement of the prior art, in order to understand what those terms mean. And that can sort of fill in the gaps. If a term seems vague initially, it may be that it's defined somewhere in the specification. So in the case that we're looking at, involving a piece of exercise equipment, we see 2 different standards announced. The Federal Circuit says that the patent claim, a given patent claim, is indefinite only if insolubly ambiguous. Even after going through all our steps for interpreting a claim properly, looking at specification, looking at dictionaries or other technical journals that explain what terms mean in that field or art, looking to the knowledge of a person of ordinary skill in the art. Only after all that, there's 2 or 3 reasonable meanings, and we just can't resolve which one it is a claim insolubly ambiguous, so I'm going to strike it down. And the court says, no, that standard doesn't make sense. We don't know how to apply it. It's too tough. And so we're going to substitute our standard. So does the claim fail to inform with reasonable certainty a person having ordinary skill in the art of the scope of the claim? Now, does this difference in language make any difference in case outcomes? Probably not, though the Supreme Court language is controlling. So a lawyer working in this area will always quote Supreme Court language, though the Federal Circuit's going to sort of make the standards, right, between these. You might think insolubly ambiguous is a tougher standard for a defendant to prove. The court standard a little lower, a little easier for a defendant to prove. But in fact, because the Federal Circuit's the one that's going to interpret and apply the Supreme Court standard, they'll use their Supreme Court's language. So, oh yes, we're deferring to you, Supreme Court. We're following what you said. Here's your language. We quoted it. But then in actual fact, it's a very high standard for a defendant to satisfy and prove that a claim is indefinite under either phrasing. Okay, so we have our example, the case that's litigated. So our inventor here, and again, patents are always granted and filed in the name of the actual inventor, or if they're joint inventors. They can be assigned to a corporation either before they're filed, right? When you first go to work for a company as a researcher, they'll often require you to sign over your patentable inventions, even before you ever come up with them. They can be assigned during the prosecution, or they can be bought and sold, assigned after they've been granted. So Dr. Leckman's the inventor here, and he's got a device for improving heart rate monitors on exercise equipment. So the problem he was trying to solve, and this is all laid out in the specifications, explain what a great invention you are. It's sort of an infomercial on your invention, why there was a problem and what you're solving, why it's great. So, you put, when you're riding the exercise bike, or you're running on the treadmill, or you're using the elliptical trainer, piece of stationary exercise equipment, or the Stairmaster type of rotating staircase, you can put your hands on the two sides, and there are electrodes there that will measure your heart rate, tell you if you're, which zone you're in, and are you working out hard, you're really out of breath, or just sort of coasting along. The problem with those initial sort of heart rate monitors where you put your hands on the two is that there are actually two signals in your hand. There's the EKG, your cardiograph, and the EMG, your muscular skeletal graph. So the EMG sometimes would override or sort of hide the ECG signals. And so those initial sort of electrode units that are measuring your heart rate would sometimes have the wrong measure. It'd be measuring your EMG rather than your ECG. And so Dr. Leckman sort of, he didn't discover this property, but he sort of took advantage of this natural law that ECG signals have a different polarity in the two hands, where EMGs have the same. So he'd measure both, and then he would use the fact that the EMG had the same polarity as a trick to subtract it out. And so he could sort of remove that, filter it out of the signals that the device was measuring, these electrodes, and you would get an accurate reading of the exerciser's heart rate. So he filed for a patent, and here's the patent. Again, we start with our preamble, our heart rate monitor for use by a user, association with exercise apparatus or procedures, comprising, that's our transitional phrase, again, open-ended. And then we have the different the different elements of the patentable invention, the things you need to make it work and that differentiate it from the prior art, at least one of the difference. And so there are various things included in here, and we're looking at the last two elements. And these are not all the elements. And so we have our electrode and the common electrode, and they're mounted on one side or the other. So we have two sets of these in spaced relationship with each other. There's some gap between the live electrode and the common electrode. And so Dr. Leckman here assigned his patent to BioSig, and when Nautilus begins selling a piece of exercise equipment that incorporated his invention, BioSig, now the patent owner, sues for patent infringement. And because Nautilus knows, hey, we're going to fall within the literal scope of these patents, so we need to argue invalidity. What's our best invalidity arguments? Novelty, obviousness, lack of utility, not enabled, not written description. So you work through all of those, and you may argue a number of them initially. Certainly in your answer, you're going to serve them all. But as litigation goes on, you sort of sort down what's my best argument. And what they argued is that space relationship is too indefinite. What does that mean? Does that mean they're 4 inches apart, 2 inches apart, 8 inches apart, 1 foot apart, 10 foot apart? And they persuaded the trial court that, yes, that term is indefinite. We can't tell what your invention is, because it could look quite different depending on what we mean by this space relationship. Well, that goes up to the Federal Circuit on appeal. Again, they're the Court of Appeals that hears all patent appeals throughout the country. Any trial court, anywhere that tries a patent case, the appeals go into the Federal Circuit. And the Federal Circuit applied their insolubly ambiguous test and said, no, people of ordinary skill in the art, given what's set forth in the description of the invention and specification, are going to recognize this piece of exercise equipment, and you're going to have a hand width, right? And within each hand, so let's use this hand because it's more readily visible, we have to have a placement of both the common electrode on one side and the other electrode, the live electrode, on the other. So it has to be within a hand width that I have both electrodes. So they can't be 10 foot apart or 1 foot apart or even 8 inches or even maybe 4 inches apart, because people's hands, the average sort of given the bell curve of how wide people's hands are that use exercise equipment, this has to work for all of them. So maybe we're talking about a 1 or 2 inch space relationship separation between my common and live electrode. But given that they both have to fit within literally the palm of the hand of the exercisers, that sort of tells you exactly what you need to know in terms of how far apart or how close together these 2 electrodes need to be. So then the defendant in the patent infringement litigation says, well, I think the Federal Circuit's test is too generous to the patent owner. It leaves too much ambiguity. Sure, if you have a property right in your invention, you have a property right in your invention, as the Federal Circuit says. But I should be able to tell as a potential competitor where your property starts and where it ends. I should be able to read your claim and know that if I use a different form or 6 inch or 5 inch separation between my electrodes, I'm outside the scope of your patent. And so they petitioned for certiorari to Supreme Court. The Supreme Court says, yeah, the Federal Circuit might have gotten this wrong, so we're going to take a look. And indeed, we say they used the wrong standard. This insolubly ambiguous is too generous, allows too much ambiguity in the sorry about that, in the patent claim. We're going to adopt this different standard, reasonable notice to a person having ordinary skill in the art. And so we're going to remand to the Federal Circuit to try again under the proper standard that we, the Supreme Court, set forth. And so you can look to the specification, you can look to the prosecution history, you can look to external references such as dictionaries or technical dictionaries. You can also look to the person having ordinary skill in the art, all to help us sort of ask or determine whether a person having ordinary skill in the art would know with reasonable certainty what space relationship in this context means. And on remand, the court says, so here's at the highest court first, right? The 2 sides, Nautilus says indefinite is subject to 2 interpretations. All it needs to be is ambiguous. So if it means 1 inch or 2 inch, that's ambiguous. BioSig says no, all it's got to do is provide reasonable notice. The court agrees with the patent holder and the US government, incidentally. Reasonable notice enough. And so on remand, the Federal Circuit, a little bit sarcastic and says, oh, thank goodness, Supreme Court, you gave us the right standard. Now we know what the rule is. And it's so much clearer than our standard, insolubly ambiguous. So they're a little sarcastic in their opinion about how helpful the Supreme Court's change here was, right? Sort of nudging the elbow of the person doing the real work in patent law, the Federal Circuit, as the Federal Circuit sees these things. Without really providing much helpful guidance. But nonetheless, on remand, the Federal Circuit panel says, well, this satisfies reasonable certainty just as well. And that's probably right, given the nature of the piece of exercise equipment and that the common and the live electrode for each hand needs to fit within the palm of the exercise user hand. So we're reading those 2 different signals for each hand. It's pretty clear what we mean by how close they need to be together and how far apart they can reasonably be. So probably the right outcome, not indefinite, and therefore the patent's upheld, and our competing vendor here is going to be a patent infringer. Okay. Now, the last reading in the chapter deals with a different way of claiming, a different type of claim language. You say, I don't want to claim the electrode. I want to claim something more general because we might measure electrical signals in the body completely differently in 10 years than we do today. And so sometimes you just want to claim the means of accomplishing a given function or result. So a means for measuring the electricity, the ECG or EMG in a hand. And so the example I want to use here is the shovel example from the first week. So we talked about having a handle and a digging head. Instead of saying a handle, could we say a means for accomplishing a function, a means for holding and exerting leverage on the digging head? And so that way you might think that the language in my patent claim, because I've said this very generally, encompasses every possible shovel. Any type of handle configuration that might work is encompassed by my claim language. That might be your initial thought when you see this sort of means plus function language, but that's actually wrong. Under section 112, subsection F, used to be paragraph 6. When you use this means plus function language, which you're allowed to use as a patent claimant or applicant or patent attorney, What we take that means for holding and exerting leverage on the digging head, it's not every possible means of accomplishing that result. Instead, we look to your written description, your specification, and say, what structure, a handle, did you set forth in the specification for accomplishing that function? And whatever structure you set forth is actually read into the claim language. So even though the claim language literally says a means for holding and exerting leverage on the digging head, when we look to your specification, the only sort of structure you give us for accomplishing that particular function is a handle. And so that language, although it looks quite different from the word handle, would actually be read just as an elongated handle. But you should be aware of that. And sometimes that can be used in particular situations. When you have a number of different ways of accomplishing a given function, you can describe them all in your specification, and then have a claim that just as a means for accomplishing that function, and it would encompass all those different possibilities. Just a different form of claims language, but I want you to be aware of it. Okay, so that's all for this week. Next week, we get into the issue of whether every invention is patentable. And we already looked at that a little bit with the Ariad case, where the court's effectively saying discovering that new pathway for treating disease is not patentable. You got to give a specific compound that would actually accomplish that result. But we're going to look at that more formally next week. So I'll see you then.